Good morning. My name's Jim Stanger. I'm an embryologist with more 50 years experience, and I'm running the short takes for FirtAid's IVF Daily's YouTube channel in an attempt to bridge the distance between published information in scientific journals and information couples need to ask their doctor relevant questions. The aim of this is to present a 4 to 5 minute video which produces one particular point of information. This particular one I found really interesting. It's from the Journal of Assisted Reproduction and Genetics, and it's called Managing Parental Capacity Concerns in IVF, the Role of Child Welfare Committees, the Survey Unit Directors. But what was interesting with this paper was it was addressing an issue that all clinics have when couples are referred to them, whether there is any issue about generating a child inside the family as they presented with. Now, 99.999% of all couples, that's not an issue, but do doctors have a duty of care? So what I thought I'd do in this case is to just read the introduction, which I thought was an excellent one. It takes about 10 minutes or so. And it summarises the issues about whether clinics have a right to exercise concern about the parental capabilities of couples coming through that require IVF services to achieve a pregnancy. Okay. So in the introduction from the authors, which are from Israel, it goes something like this. So I'm reading it verbatim. This is an open access article, so I can do this. It reads something like this. Child welfare risks represent a serious global concern. In 2021, the US reported that 8.1 out of every 1,000 children were victims of abuse or neglect. In the UK, 4.3 out of every 1,000 children were on child protection plans. Parental risk factors such as substance abuse, mental health disorders, single parenthood, and incarceration are identifiable before pregnancy. This raises ethical dilemmas for fertility clinics and counsellors regarding the prospective parental capacity of patients seeking fertility treatment, including whether to deny treatment based on potential future risk to the children. The welfare of the child principle in reproductive medicine emphasises the clinician's ethical obligation to consider the well-being of the future child. However, the extent of clinicians' responsibility to assess PC and possibly deny treatment remains subject to some debate, and this is why I think this paper is actually very good. A full presentation of the physiological and bioethical aspects of this issue is beyond the scope of the text and has been discussed elsewhere. And if you want to do that, you can access the article and then chase up these references. It is suggested, however, that individuals with infertility have the same reproductive rights as those who are fertile. As fertile individuals do not require approval to reproduce, the same standards should apply to those requiring medical assistance. Therefore, withholding fertility treatment on the basis of concerns regarding parental capability constitutes discrimination against infertile individuals. While child welfare assessments aim to protect future children, they may unintentionally contribute to reproductive stratification. So, for instance, in Sweden, assessments are mandated for ART using donated gametes, which can disproportionately impact non-heteronormative families. Wow. Such disparities highlight the need for transparent, equitable assessment criteria. On the other hand, unlike spontaneous reproductions, clinicians are involved in the reproductive process for infertile couples and carry joint responsibility for the welfare of the child because of he or her casual or intentional contribution to the parental project. Hence the clinicians have a moral duty to refuse collaboration if there is a high risk of serious harm to the future child. As stated by the ESHRA task force, and in quote, the fertility specialist should refuse to collaborate in the parental project of the would-be parents if he or she judges there is a high risk of serious harm to the future child. Similarly, the American Society for Reproductive Medicine Ethics Committee permits the withholding of services when there is a well-founded belief that prospective parents may not provide adequate care. This predicament is not merely theoretical, but also a practical concern for fertility clinicians and counsellors, leading to many questions. Who is entitled or obligated to refer infertile patients for parental capacity assessment? Which patient should be assessed? Who makes the final decision on authorising or denying treatment? And finally, how should clinicians communicate these decisions to patients? Fertility specialists are often reluctant to assume this judicial role as it conflicts with their primary mission to help individuals achieve parenthood. And this is one reason why this introduction is so good. To address these challenging issues, countries have established different legal and professional frameworks. In the UK, the Human Fertilisation Embryology Authority HEFA Code of Practice, which stems from the Human Fertilisation and Embryology Act 1990, considers this issue. According to the code, clinic staff have an option to deny treatment, but they are also obligated to do so in cases at risk. The centre could refuse treatment if A, concludes that any child who may be born or any existing child of the family is likely to be at risk of significant harm or neglect, or B, cannot obtain enough information to conclude there is no significant risk. The HFEA mandates a welfare of the child assessment for all IVF patients. This may involve completing a welfare of the child form, gathering information on the medical, psychological, and social history of prospective parents. The assessment aims to identify serious concerns about the child's future well-being, focusing on risk factors such as substance abuse, criminal history, and home environment. The responsibility for conducting assessments lies primarily with the clinical team within fertility clinics. While the HFEA encourages the use of clinical ethics committees for complex cases, their establishment and consultation are not mandatory. Decisions regarding treatment, approval, or denial are typically made by the clinic director, who may seek guidance from social services or external experts when required. In Norway, the assessment of future parental capacity for IVF patients is mandated by law, which requires medical and psychological evaluation of the woman and any partner, taking into account their capacity for care in the child's best interest. The evaluation must be conducted by the ART physician, who has the discretion to involve a psychologist or counsellor, but is not required to do so. In 2020, a police certificate is also required, which includes a check for criminal offences relevant to the child welfare, including abuse, physical violence, and serious drug-related crimes. However, the final decision to approve or deny treatment lies with the ART physician. Doctors in public clinics have access to clinical ethics committees for guidance, but consultation is voluntary and non-binding. If treatment is denied, patients can appeal to the county governor or seek treatment at another clinic without obligation to disclose the previous assessment. According to Swedish legislation, an ART treatment with donor gametes should be offered only if it can be assumed that the child will grow up in good circumstances. However, when a couple's own gametes are used, there is no legal requirement for such an assessment. That's interesting, isn't it? In the Netherlands, the assessment for future parental capacity for IVF patients is guided by the model protocol on possible moral contraindications for fertility treatment developed by the Dutch Society of ONG. The decision to provide or refuse fertility treatment is made through a multidisciplinary consultation involving clinicians, psychologists, social workers, and potentially ethicists and legal advisors. Dutch law allows clinicians to refuse treatment if there is a significant concern about the child's welfare. Physicians are not required to actively investigate reasons or deny treatment, but must act if clear concerns arise. The clinic director is responsible for the final decision, though it is made in the context of a multidisciplinary team's recommendation. According to the Ethics Committee of the American Society for Reproductive Medicine, fertility programs may withhold services from prospective parents if there are well-grounded reasons to believe they will be unable to provide a minimal, adequate, or safe care for offspring. The ASRM recommends that fertility programs develop written procedures for assessing parental capacity when concerns arise. A program's assessment of a patient's inability to care for a child or potential to cause harm to a child should be made jointly among members of the program and, if indicated, consultation with appropriate other professionals should be documented. And finally, in Israel, the assessment of parental capacity is typically court-ordered and focuses on existing children. No clear legal framework addressing prospective parenthood before a child is born. According to the recommendations of the Israeli Ministry for Health, every IVF unit in Israel must have a social worker or psychologist, and all patients are to be offered an introductory meeting during the unit's intake process. Additionally, a psychosocial assessment may be initiated by the medical team if concerns arise regarding the patient's suitability for treatment. In routine IVF practice, fertility patients are not typically required to disclose criminal records, nor are they routinely referred for psychological evaluation unless a specific concern emerges. However, in 1990, a 1990 directive issued by the Director of the Ministry for Health stipulates that if concerns arise regarding the prospective parent's political capacity, a mental health professional must assess them. Based on this assessment, treatment may be denied if deemed necessary. In 2012, a governmental committee established by the Ministry of Health to examine regulatory issues regarding assisted reproduction recommended the establishment of an advisory CWC in every fertility unit to alleviate the burden on individual clinicians. The advisory committee should include a gynecologist, a social worker, a psychologist, and a medical specialist who is not a gynecologist. Fertility clinicians may, at their discretion, refer patients to the CWC for assessment, seeking recommendation on the provisions of fertility treatment. The CWC would be able to share the significant onus of these decisions beyond the individual clinician's responsibility. However, these recommendations are not fully adopted or incorporated into Israeli regulations or law, resulting in ambiguity in regarding denial of fertility treatment based on questionable PC. In certain countries, denying fertility treatment on the basis of future parental capacity may depend upon whether fertility treatments are provided in the public or private sectors. The Israeli healthcare system provides comprehensive medical services for all citizens, including fertility treatment. Medical care is delivered through 4 health maintenance organisations, each responsible for providing a standardised healthcare service package. Fertility specialists may face significant pressure to provide treatment despite ethical reservations, given the perception that fertility care is a fundamental right due to the extensive public funding for fertility care. This further complicates the medical teams to discuss decisions regarding fertility treatment in terms of parental capacity. So I might leave it. This is the reason I raised this is that couples coming through IVF basically are doing so in the interest of having a healthy child, and really these issues occur very rarely. But almost all clinics, particularly in this survey, have experienced one or more episodes where they have been concerned about the future welfare of the child. And the responsibility lies in the initial workup, both for the referring doctors and the counsellors and clinicians, is to assess whether there is a risk. We note, of course, that patients are not required to give details of previous criminal records or other issues. It's up to the clinics to make some decision about whether they should proceed. But they should be able to deny treatment if it's been fully documented and discussed at a team meeting and the reasons given why. Patients, of course, may have the right to sue, but most likely they will just go to another clinic. I hope this reading of the introduction of this article has been of value for us, and it makes people go back and realise that the level of care of an IVF clinic is really directed towards the health of the child, not to the couples having an IVF child. Thank you.